Keeping your business healthy in today's marketplace can be a challenging and overwhelming task. From the threat of litigation inside and outside your organization and the inefficiencies that can rob your bottom line as a result of unproven marketing programs, the deck can be stacked against you. To get ahead of these challenges and stay ahead of your competition, the Bottled Business Sense Show provides practical business solutions that uniquely emphasize key legal principles, management techniques, and marketing strategies to protect and ensure the longevity of your business. You'll learn how to implement marketing and protection principles equal to those used by today's most successful corporations. Join your host, Bill Bernard, Rick Moscoso, and Steve Smith for some high-energy discussion that will inspire you to take control of your business so it can prosper in today's consistently challenging business environment.
Well, good morning, everyone. Today is Tuesday at 10:30, again here on the Bottled Business Sense Show, and thank you for joining us again. For all you our returning viewers and listeners, welcome. And today we have a great topic in regards to some legal tips. But before we get into that, we're a simulcast show that we offer business tips, both in marketing and legal aspects to the small business owner. And we have quite a library of topics in our on our website. You can always go visit that and look at previous episodes at bottledbusinesssenseshow.com. We also simulcast on Blog Talk Radio for all you listeners at blogtalkradio.com/Bottled Business Sense Show. And we're all over social media, so you can reach out to us there, as well as if you have an interest in being a guest on the show, please reach out to us. You can always drop us a message at bottledbusinesssenseshow@gmail.com, and we'll take a look and share your topic. So with that, I am here today. My name is Rick Moscoso with Captivate 365, and my other co-host on the other side, several thousand miles away, is Mr. Bill Bernard with WFB Legal Consulting, Inc. So let's bring him onto the show. And how are you doing today, Bill?
Doing fine, Rick. Thank you. Yes, I'm out here in the middle of the ocean. However, I will be back soon, and we'll look forward to getting back in the studio. I think we have an interesting topic today from the perspective of from a practical perspective. I get a lot of questions on this, and it has to do with estate planning. As everybody knows, my business model as a business attorney involves employment law, involves incorporation and LLCs, and also estate planning, because I think they're very intimately tied together. Well, I get a lot of questions all the time about owners who own businesses and want to leave their businesses to somebody. And of course, my instructions to them are always to put the business in a trust and make sure that we get this thing done appropriately, privately, and without any court intervention and unnecessary expense. Well, some people don't do that, and some people end up leaving a business by way of a will. And so the question I get typically, Rick, a lot is, do I have a right to see the will? Well, the essential answer to this question is, if you die with a will and without a trust, you die intestate. You have a will, you die intestate. If you don't have a will, you die what's called testate, Testate. What's the distinction? The only distinction of having a will without a trust is the will requires you to go to probate court and decide who gets what, because the will says who's going to get what. Now, the will can always be disputed, of course, and so forth and so on. But assuming it isn't, a will just simply says, here's who's getting my stuff. I wasn't smart enough to do a trust, so the court's going to have to figure all this out. If you die without a will, intestate, then the court's going to pass it on by way of intestate succession, by way of a law that's provided as to who gets what, and depending on how they're related to you. Well, today we're going to deal with somebody who dies intestate, who has only a will, because again, the question I get all the time is, do I have a right to see the will? And
when you let's get some clarification on that. So when you're saying to see the will, are you talking about your own will or somebody else who's administrating it?
No, I'm saying if you die, and I ask the question, do I have a right to see Rick's will, and to see who he's leaving stuff to? That's the basis of the show, and that's going to turn on several different factors. And we're going to presume, for the sake of the discussion on this show today, that you are a loved one of some sort. Okay? Because if you're not going to see the will. Unless you are a beneficiary of that will, at which time the executor of the estate has a duty to make it known that you're going to be receiving something from the will. So let's lay it out. Very simple. If you are a loved one, you have a right to see the will by asking the executor to show it to you. If the executor doesn't want to show it to you, you can file a probate action seeking to open probate and ask to see the will. And you're going to have to provide a basis upon which you can see it. If a probate's already been opened, then you're going to want to be an interested party and make a claim as to why you should see the will if, in fact, you believe you have a right to, and if, in fact, the executor doesn't want to show it to you. Now, if an executor is working the way the executor is supposed to work, and you are a loved one, I'm probably going to say, yeah, I'm going to let you see the will because you're a loved one. So I want you to know that you're not included or you are included. If a probate's already been opened and the executor doesn't want you to see it, then you're going to have to go to court to let him make you see it, and you're going to have to establish why you have a right to see it. If a probate hasn't been opened and the executor won't let you see it, then you're going to have to open a probate with the court and explain to the court why you have a right to see it.
So for what reason would an executor not grant access to a will for a loved one?
No, who knows? It could be a number of reasons. Could be just a lousy executor who doesn't know what his or her duties are. It could be that the testator, the person who made the will, has said, I don't want Joe Blow to know anything about my will. If that's the case, then no matter what you do, the executor is going to be able to back it up, right? He's going to be able to establish that you don't have the right to see the will pursuant to the direct instructions of the testator, who's the person who made the will. Now remember, there's one little backdoor item here. Remember, I've talked about the fact that trusts are typically private. They're always private. You'd never file a trust with any court. One of the advantages of having a trust is that your estate is kept private. That's one out of many advantages. When you have a will and it is probated, that will is filed with the court. Therefore, it becomes a public document. And so you can access court records and read the will, right? And find out who leaves what to what. So somebody who wants to wait a period of time for the will to get filed by way of the petition to open probate is going to be able to access those court records as public documents and find out what he or she wants to know anyway, right?
Right.
You typically want to contact the executor first because you're trying to do it in the most efficient and expeditious manner possible. But you may end up having to look in the court records. If for some reason the will isn't filed with the court, which it should be, then you're going to have to get involved in the court process and demand that the court have a copy of the will if the court doesn't do it on its own already, because typically the court's going to say, hey, what's going on here, bud? You opened up the probate. Where's the will? Right?
So how soon after the will is filed in court is it accessible by the public?
That's a tough question, Rick. That could be different in every court. That is a matter of county bureaucracy and how soon they get the court records up to date and allow it, because you got to remember today, in today's access, you have not only being able to go to court, but you have online access in many courts. Some are for free, some you're required to pay. But if you want to wait till it gets to be online, who knows? That depends on how efficient the county is and how efficient they are in making sure their documents get posted. So that's kind of a tough question to answer. But I think I also want to mention that if you know somebody who has a copy of the will but won't turn it over to you, like the executor, you can file a motion to compel in probate court to seek a copy of that will if you believe you are entitled to it. Of course, that motion is going to have a substantive basis to it as to why you have a right to see it. And I should tell you that an interested person is someone who is named in the will or who would have a right to receive the testator's property if that person died without a will. And that would be spouses, children, or parents of the deceased testator. Those are what's called interested persons. Those are people that would have a right to see it. Unless, of course, the testator makes clear that he or she doesn't want anything going to the beneficiary who wants to see the will. That's kind of a tricky issue because the beneficiary is going to claim, I still have a right to see the will. Just because I don't have a right to get anything under the will pursuant to the testator's wishes doesn't mean I don't have a right as an interested person to see it. So that person's going to compel the court to let he or she see it, and then to their dismay, they're going to find out that they're not going to get anything under it unless. But see why that right is so important, Rick? Because what if that person who's not going to get anything wants to file a will contest, wants to contest the will? Say it was done under duress or undue influence or something of that nature. That person wants to have that right exercised because maybe it's as important to see that he or she doesn't get anything as it is to see whether they do get anything.
Yeah. So let me ask you a question in regards to that. So is it, are you saying then if it is public record and it's not put into a trust, somebody can go online, look up the will. Now, is that published after the person dies, or is it published when the document was submitted?
No, it's never submitted before death because it's going to be submitted by way of the opening of a probate, and that only occurs when the person is deceased, the person who made the will. But I want to kind of just add one little thing on here before we end the show. It's a rather short show today, but it's right to the point, and it's a question I get all the time. How does this tie into business? Well, many times a business is left in a will, right? Mm-hmm. And many times a business is left to an interested person, spouses, children, parents of the deceased, or even left to a friend. And that friend may want to know what his or her rights are and may have to wait till it is a document that's a matter of public record. Or that person then goes in and files, tries to establish that he or she is an interested person by way of filing a motion with the court once probate is opened, or may even take the initiative to open probate on his or her own if one hasn't been opened yet, depending on how quickly that business needs to be transferred so it can keep to be operational on a continuing basis. So the question, what begs the question here is, yes, it's important to pass your business assets on, but why would you want to pass it on by way of a will? Pass it on by way of a trust. The trust is not public. The trust doesn't have all of the expense attached to it that a probate does. You are able to get things done conveniently and much more quickly by way of a living trust. And remember, in a living trust situation, you do have a will as part of your trust package, but it's a pour-over will. So let's say you have let's say you have two businesses and one is left in a trust. The other business isn't left in the trust. It isn't put in the trust. You can file with the court pursuant to the pour-over will that was created by the trustor or testator. You can say, hey, Joe put this business in the trust and he left it to me. His intention was to leave the second business to me, and that second business should pour over into the trust by way of the pour-over will. And that's what the pour-over will is typically used for, in terms of pouring over property that was left out of the trust to begin with, because you need to show the trustee's intent that he or she would have more than likely put that in there had he or she remembered to do so. Maybe it was a business that they just started and they didn't get a chance to put it in before they died. That's another circumstance. So anyway, the point of this show is, Rick, not only that you should have a living trust package, but if you do just have a will, what your rights are in terms of being able to access that will and find out exactly what's going on. And when you talk about an interested person, you're typically talking about someone who stands to inherit property by way of the will, and who doesn't want to wait the length of time it might take for the will to be made a matter of public record.
So as far as an executor who's responsible for executing the will, typically what's the timeline after the person's death? Is that opened up?
Well, you have to open up a probate as expeditiously as possible, but there have been egregious incidents that have occurred where probate hasn't been opened up for quite a long period of time. The typical way that it works is usually within, in my practice, within 30 days of death, I send out information that the interested parties need to be aware of, and then make sure that I have an executor in place to open up a probate in a timely fashion. If a probate isn't opened up, again, an interested party on his or her own can go in and file to have the petition for probate opened. So you need to see an attorney in your state of residence to clarify exactly what needs to be done when. See an estate planning lawyer. Make sure you get that information made available to you. I wanted to say here at the close of the show, by the way, Rick, that you mentioned at the beginning of the show that we are on social media. I wanted to mention we have a Bottled Business Sense Show website. We have a Bottled Business Sense Show LinkedIn site. We have a Bottled Business Sense Show Twitter account. We have a Bottled Business Sense Show Facebook account. All you got to go in there and do is just type in Bottled Business Sense. It'll come up, and it'll give you the various email links or Twitter links that you need to use to get in contact with us. And we do strongly invite people to come on the show, because our goal here is to tie in a business owner's recognition of being able to move his business forward in a prosperous way by knowing and being aware of his business rights, both in the area of employment law, asset protection, and estate planning. And many times, when I do something for a business owner, the business owner will say, now you took care of my business, can you take care of my personal assets? Can you make sure they're secure and passed on the way they need to be?
Mm-hmm.
So,
well, that's great. That's great. I mean, this was a very short and sweet show, and I would like you to just recap for our viewers, in your opinion, what is the most optimal way to do a will or encompass it so you're fully protected? And I mean, what would you suggest to a person that comes to you and wants to do all this stuff? How would you wrap that up so they're fully protected?
Well, let me first clarify that they're never going to be fully protected. An estate plan, unless it's an estate plan that encompasses an irrevocable trust, which transfers property from the person making the trust to another third party, you're never going to be protected by way of either a revocable trust, which you can revoke at any time, or a will. The purpose of a trust and a will is to pass property according to your wishes. So, with that clarification, what I would do when they came to me is say, you don't want to do a will by itself. It's meaningless. It really has no value. You're going to end up causing your heirs the same amount of stress and expense that you would if you didn't have a will. So I would tell them to make a revocable trust if all they're interested in doing is passing their property in private and without a huge amount of expense. I would say get a living trust, get powers of attorney for asset, powers of attorney for healthcare, get a healthcare directive, get a pour-over will, get a trust certification. All of those things combine into what I call a trust package. And you can come in and get that done in one fell swoop, and you're good to go. And then you don't have to worry about people wanting to know what's in your will. Now, as a trustee, whoever the trustee is at the time you pass, they have an obligation to get a hold of the beneficiaries and make the trust available to them. But we've covered that, I think, in other shows, and that's a story for a different day. But the point is, I would never recommend somebody, Rick, to come in who comes into my office and who wants a will. Now, if the person only wanted a will, and they said that's all I want, I would probably do it for them if it was something that was something for that they just felt for some strange reason they wanted and without anything else. But I would do my best, I'll tell you, to persuade them not to just get a will. If they
do you find then in that situation that maybe it's just out of lack of knowledge that they never considered a trust just because they didn't know?
Yeah, more oftentimes it is. Sometimes it's a matter of expense. Just doing a will by itself, of course, is not as expensive as doing a living trust package. But I'll be candid with you, it's not that less expensive, and it's you get a whole lot more by having a trust package than you do with a will. So I can't tell you the last time I just did a will for somebody. I will typically try to talk people out of that. First of all, I get very few requests for just a will. The requests I do get for just a will are so few and far between that when I try to talk them out of it, I typically say it's really not worth our time and money, and they walk away. So I might have done if I've done 2 wills by themselves in the last 10 years, that's a lot. So,
okay. Well, great. This has been a great episode. Folks, if you are interested in pursuing doing the right thing, as Bill outlined today, please reach out to Bill. He's definitely an expert in this area, and he's always open to discussion. So, Bill, why don't you share your contact information and how people can get a hold of you?
Sure. WFBLegalConsulting.com will have my phone number, which is 949-413-6535. My other business number is 949-698-6222. That's my office number. And again, you can contact me at bill@wfblegalconsulting.com. bill@wfblegalconsulting.com. You can also find me, of course, on LinkedIn and on Facebook and on Twitter. Just Google WFB Legal Consulting, punch in the search engine for each of those sites, WFB Legal Consulting, and you will see me pop up. And I'm happy to discuss this on the phone with you. I have no problem giving you a free phone consultation whatsoever. So please don't let that stop you from finding out the information you need to find out, because we're here to do it for free. We're here to give you this information on the show for free, Rick. It's at no cost to you. Explore it, decide what's for you, and act on it, because you'll be the better for it down the line.
Yeah. Well, that's great. We're all about helping business owners and individuals out there do the right thing when it comes to the subject matter that we talk about. And Bill's a great example of that, contributing his time to make sure you're fully informed when you are ready to make that decision. So with that, Bill, I want to thank you for all the information that you shared today. And again, folks, reach out to Bill if you have any questions or concerns regarding your particular situation. And with that, Bill, aloha, and look forward to seeing you on the next episode here on the Bottled Business Sense Show.
You got it. Thanks, Rick, and goodbye, everybody. Have a great, prosperous week.